Order, members, please. The question is that parts 1 to 9, schedules 1 to 6 and clauses 1 and 2 stand part.
Mr. Chairman.
Charles Chauvel.
Thank you, Mr. Chairman. Mr. Chairman, the committee stage debate will include debate of the supplementary order papers, which the Minister's just referred to. I want to talk about some of the changes that are made in the Minister's supplementary order paper and indicate that the opposition will support those changes because they are the result of an agreed and negotiated process.
Thank you.
I want to place on record my thanks to those parties in the House that have worked with the Labor Party to bring about these amendments, in particular the ACT Party, the Māori Party, and to the Minister for agreeing to the amendments. I also acknowledge the work of the Green Party. It was they were quite willing to be involved in the discussion in order to try to get to the position that we've got to today. And it was always a pleasure to work with Kennedy Graham on the issue. I'm somewhat sad that wider discussion didn't occur, but that might be a matter that the Minister decides to touch on at some point this afternoon, since that was effectively his decision. In terms of the main objections that were made by the Labor Party in our minority report concerning the original draft of the bill, I think these are now well known. We didn't like the idea of raising the jury trial threshold from the current level of 3 months to the level of 3 years as was originally proposed. Now, in respect of that matter, sir, we have a proposal in the Minister's supplementary order paper to continue to raise the jury trial threshold, but not to the level that was originally proposed. The new level proposed is 2 years, so it's a difference of 1 year only, as opposed to the difference between 3 months and 3 years. I think if members look objectively at this question, they'll see that it's a much better system. It has to be said, the evidence given at the Select Committee and the analysis delivered in favour of a 3 month threshold really didn't, in the view of many members, including myself, stack up. And in order to make the sort of fundamental change that would have been contemplated under that measure, I think really it was incumbent on the government to make a better case than it did. Now, why 2 years as opposed to 3 years? And I know that this is a matter that the Green Party doesn't agree with and will want to take issue with and take some calls on. Well, I think I ought to admit first off, there isn't a lot of science to it. And the problem we have here is the lack of analysis that I referred to just now. We didn't get, in my view, the sort of careful consideration of what the new jury trial threshold should be. And as I've said before, sir, when this House deals with the New Zealand Bill of Rights Act, as we are, and seeks to amend it in a way which derogates from rights as opposed to augmenting rights, greater care ought to be taken. Nonetheless, for the sake of getting agreement in order to preserve such fundamental liberties as the right to silence, we were willing to agree to the 2 year threshold. And there is some logic to it. If members care to look at the Crimes Act, they can see that there is something of a delineation in the regime concerning offences. More serious offences tend to be tried at above the 2 year imprisonment level, and less serious offences obviously fall below that line. So I think the example I gave in the second reading speech was male assaults female or the assault by an adult on a child. It will still be possible for that sort of serious level of offending to be the subject of a jury trial if the defendant insists on it. So there will still be a safeguard for relatively serious offending at that 2-year level. Could we have chosen another level? Could we have engaged in a less arbitrary process? Would that have been more desirable? Absolutely. But as I say, in order to, Mr Chairman, in order to preserve and maintain a position where a better solution than simply the 3-month threshold was achieved, this is where we find ourselves, and I do urge members to look carefully at the position as it stands. So the other major problem with the bill as it was originally proposed is that it did make major incursions into the right of the defendant, of an accused person, to say to the government, if you say I am guilty of an offence, then you must prove all the elements of that offence. I, as the person that you have accused, am not obliged to help you prove me guilty. And that's a very important principle. I needn't labour the point. Now, government members in the past have referred to the provisions in the bill as simply an innocuous way of bringing a bit more order and hygiene to the criminal justice system by requiring the defence to disclose the broad outline of its case to the prosecution and saying, well, that's really not a problem, it's just a way of trying to speed the system up. Well, sir, that's nonsense, and I'm glad that the Minister has agreed that these incursions on the right to silence should go. The House of Lords back in 1930, when the state was much smaller and much less powerful, set out a ringing defence about the requirement of the Crown to always do its job to prove all the elements of the offence. The state is much more powerful, it has much more resources available to it now. The citizen needs more protection than ever, and by agreeing to retain the right to silence, this Parliament has done what it should do in this case, and I'm pleased to be able to say that we are supportive of the way in which the amendment is drafted. Now, sir, there are a number of other matters that are dealt with in our minority report, which the Minister has agreed to action, but there are also some further matters which I have thought should be dealt with in the legislation in order to try to speed up the criminal justice system without compromising the fundamental rights of New Zealanders. And I have proposed these measures in a supplementary order paper number 286, which is on the table. And I just want to speak to the amendments that are set out in that supplementary order paper. The first relates to inserting a new section, a new clause 25A. This would apply only in cases where a person was arrested under what we're now going to call a Category 1 or a Category 2 offence. This used to be summary offending or indictable offences that were able to be dealt with summarily, so they're the more minor types of offences. And it's a situation where you can't immediately bring the accused person before a court. So they're arrested for a relatively minor offence. You can't bring them before the court in a speedy fashion. This provision that I'm proposing would allow the arresting officer to release the defendant under the section and serve them a summons that would require them to come to the court within 2 months of the offence. And it sets out some provisions there. It's really designed to try to speed up the system, as I said, without prejudicing the accused person or the person arrested. There's a similar procedure set out in suggested clause 26, which would relate to what should happen following an evidential breath test. Then in clause 35, sir, I've set out a provision that I understand codifies existing practice, but it is not a practice that's written down anywhere, and I think it would be useful if the courts were to put this practice into effect rather than simply have it as something that is observed as good hygiene. There's a practice known as disclosure. So the Crown has to give disclosure against the defendant. That's the point at which the Crown sets out its case, says here's the evidence we have, this is what you must respond to during your defence. And, Mr Chairman, the bill...
Charles Chevelle.
Thank you, sir. The bill proposes, or the SOP proposes, that the defendant should have 21 days to consider the disclosure before having to plead. Now, before anybody thinks this is simply a pro-defendant move, it's actually designed to try to speed the system up. At the moment, if you're required to respond immediately to what you get from the Crown, of course what you do is you enter a tactical plea of not guilty, because it buys you time to respond. If we put a 21-day limit in, then we'll actually avoid a whole lot of tactical not guilty pleas, and we'll achieve the Minister's end, trying to speed the system up without doing anybody a disservice. Then clauses 58 to 63, I've tried to set out a statutory basis for a very good system that operates in our courts at the moment, the sentence indication system. Again, it just operates informally off the back of the inherent powers of the judge to do justice. This is a system where we can avoid trials going forward by allowing a judge to say, well, if this went to trial on the basis of having read the file before me, you would probably get this sentence. And the defendant can think, well, maybe I should just plead guilty to this on the basis of that sentencing indication and avoid a trial and get a discount for an early guilty plea effectively. No statutory basis for that at the moment. Very sensible system. I'm trying to put it in the Act so that we can actually have that going forward. Clause 105 modernises a silly piece of the law that says that you can't address the judge in the district court at certain times on the evidence. There's no reason for this archaic law to exist anymore, this practice. We should do away with it. Again, we might speed up the trials. Clause 128 will further confine the circumstances under which trial and sentencing can continue in the absence of the defendant. The Minister's agreed to narrow that quite considerably in response to a request from me and others, and I'm pleased that that's happened, but I would narrow it further to say that the court may not proceed in a defendant's absence where a reasonable excuse for that absence exists. A good simple test known to the law at the moment won't need to lead to a whole lot of test litigation, and we can proceed on that basis. Two final changes. Clause 176A will prevent the prosecution from offering new evidence or from correcting deficiencies where it could have done so earlier but simply failed to do so through its own oversight. And finally, clauses 361 and 362 will restrict the circumstances in which the court can give a costs order against a defendant or a defendant's counsel, two situations where a failure on behalf of one of those two individuals is exceptional and intentional and done without reasonable excuse. Now, I do hope that I haven't lobbied the House for these amendments or gone around asking for support. I hope that the House will consider the amendments with an open mind. They would, I think, lead to a better system, sir. And along with the Minister's amendments, which we've agreed, I do think we have a better bill. It's not a perfect bill. There is much more work to do in making our criminal law better, quicker, fairer and more responsive. We could start with the drivers of crime and address them in a multi-party fashion, and we could then have a look at updating the Crimes Act 1961 and the Summary Proceedings Act 1957. Many would say and have said those would have been better places to start than diving right into the procedure and the evidential rules, which is what this bill does. Nonetheless, that's the choice the government has made. We've done our best on this side of the House to cooperate, to offer constructive criticism and to put forward amendments, whether on time or not, that try to make the bill better so that New Zealanders do have a more efficient court system as far as the criminal law is concerned. I do hope, sir, that we will get intelligent debate in this slightly short